Hello, my wonderful people. You are once again welcome to this class. It is a privilege and an honor to have this tutorial with you wonderful people. For the many that have subscribed, like, and be commenting, thank you very, very much. I really appreciate your comments. Feel free to share and ask your questions, and we'll do very well to respond to them. So today we'll be dealing with a very simple, really pretty straightforward topic. We will try not to, belabor the point and go straight to it. Today we'll be dealing with sources of law in Ghana. So if you're a law student, you would find this very, very interesting because all the laws that govern the various sectors of the government, all the laws governing the various arms of government, which is the executive, judiciary, legislature, must be coming from somewhere. Someone must be making these laws. So where do these laws come from? So today, that is what we will do. So we will just try to provide a bit of color to where we get our laws from. Now, so quickly into the substance of what we'll be dealing with today. So we'll be looking at the meaning of sources of law. We'll be looking at Article 11, which is the main provision of the Constitution that tries to explain the sources of law. We'll also be looking at, so yes, the Constitution, enactment, existing laws, orders, rules, yeah, quite a host of them. We'll go deeper into it. So the first bit is sources of law. So when we say sources of law, what are we trying to say? So when we say sources of law, we are trying to identify the validity of the laws. So what makes law law? Why should we obey a particular law over the other? Why should we treat one law as more important as the other? Where do these laws come from? So we are looking at their authority, we are looking at their validity. These two terminologies are very, very important if you want to understand the meaning of sources of law. So where are these laws coming from? Who makes them? What authority makes these laws? Now, what makes these laws valid? Can anybody just sit in their Ghana and make a law and expect everyone in Ghana to obey it? No. So meaning that by virtue of certain authority given to certain persons, they can make laws for all of us to obey. By the authority given to a certain agent of government, they can make certain laws for us to obey. So that is what we mean by sources of law. So when you get a question on discuss the sources of law, you need to explain what the sources of law are. And I've said that when we are looking at the sources of law, we are looking at the authority of who is making the law and the validity of what makes the law. So what makes one law more prominent over the other? It means that there's something about the law that gives it the validity which allows all of us to obey it. This is very, very, very important. Good. Now, the main provision that tries to put together all the sources of law in Ghana is Article 11 of the 1992 Constitution. You just cannot forget it. It's Article 11 of the 1992 Constitution. And Article 11 says that the laws of Ghana shall comprise the Constitution. So it's quite interesting because the Constitution in itself is saying that one of the laws of Ghana is itself. And then the Constitution again, as if you watch the other videos that we've talked about enforcement of the 1992 Constitution, if you look at Article 2, it says that the Constitution shall be the highest law of the land. So the Constitution is the highest law of the land. So meaning that when we are talking about the hierarchy of laws, just from the onset, you should know that the highest law of the land is the Constitution. It doesn't matter that is the Constitution that is saying that it is the highest law of the land, but we've all come to accept that it is the highest law of the law. When you read elsewhere, it's talking about the Grunum. I'm sure you may have heard of the term Grunum. If you haven't, you can check it out. It's spelled GRUNDNORM. I think it's a topic that the law student would deal with in jurisprudence. Yes, I think so. So it really talks about the validity of laws, what makes a particular law, that crime that all other laws subscribe to it, because we have all agreed that the constitution must be the highest law of the land. And I understand that it is we, the people, that have given the constitution that authority, because we make up the government. The constitution is for us. We are not for the constitution. So we, as a collective people, have agreed that the constitution must be the highest law of the land. So after the constitution, there is no other law. It is the highest up there, and then the other laws follow suit. So the highest law of the land is the constitution. Now, after the constitution comes enactment. You also see in other places acts of parliament. Now, what these are essentially are the laws that are passed by parliament. Understand that under the three arms of government, parliament has been given the authority or the mandate to make laws. So the law that parliament makes are what we call acts of parliament or enactment. This is very, very important. So any law that parliament makes, it is called an enactment or acts of parliament. And understand that parliament has this authority because the constitution says that parliament shall make laws. This is very important. So when we're talking about the hierarchy of laws, the highest on it is the constitution. Next are enactments, which are also called acts of parliament, and these are laws made under the authority of parliament. So parliament, passes these laws. I think in other topics that we'll be looking at how bills are made, because understand that they come as bills and then they go out as acts. We'll be looking at the process that is done, but that is it. And then we also have orders, rules, and regulations, and these are made by persons or authority under a power conferred by this constitution. So let me take my time to explain this. So what this means is that in the constitution, certain authorities of government, like the Electoral Commission, like the National Media Commission, like the police, the army, the fire service, and whatnot, all these authority and persons are given power. So these authorities are allowed to make laws, and the laws that they make are the orders, the rules, and the regulations. Understand it. So let me use the Electoral Commission again. So the Electoral Commission under the Constitution has the power to make laws that would guide how elections are conducted in Ghana. Because even though the main electoral laws will be passed by the Constitution, when it comes to the day-to-day affairs, what is a misvoting or a wrong voting, or who qualifies, or the credentials that you need to stand for as an assemblyman or unit committee head, such nitty-gritties will be provided for in the regulations that will be passed by the Electoral Commission. So understand this. So all the bodies, so you could have the police issuing orders, rules, regulations on how its officers are supposed to act. They could be issuing orders, especially the police, on how we are supposed to present ourselves in certain way, we are supposed to be cautious and all that. These rules, orders, and regulations do not come from parliament. No, they come from authorities established under the constitution. So you would really, really want to understand this. And sometimes, so in there, like you have the executives, they do executive instruments. So you have instruments coming from the president, so the president on how certain things are supposed to be done. We also have constitutional instruments, so all bodies established under the constitution, they can do that. So the executive power, they also have laws that they pass, and normally we will call those executive instruments. So we have executive instruments, we have constitutional instruments, and we have legislative instruments. Those are also instruments that guide what Parliament does. To orders, rules, and regulations by the Electoral Commission, by National Media Commission, by Commission for Human Rights and Administrative Justice. Those laws are not necessarily from Parliament, but they are from entities that have been given the power under the Constitution. I hope this is clear. If you listen to this audio and it is not clear, you can always put in a question, and then we'll come back and then throw more light on it. So next in line is existing laws. So existing laws are essentially all laws that were in place before the promulgation of the 1992 Constitution. So all the laws, that all the decrees that were passed during the military regimes, those that are consistent with the Constitution are existing laws. If they are not consistent with the Constitution, as we have already mentioned, they are in itself now and void. So once such laws are consistent with the 1992 Constitution, they are deemed as existing laws. So all laws before 1992, all laws, once they don't contradict or contravene the 1992 Constitution, they are deemed as existing laws. This is very important. I hope you understand. And there are quite a few of them around. And the very popular one is PNDC Law 111. PNDC Law 111 is an existing law. I think another popular one was the Conveyance Decree 1973, which has now been repealed by the Land Act 2020. But there are few popular existing laws around. All these laws were passed before the promulgation of the 1992 Constitution, but because they are good law, they are still, or they still form part of our laws, and we refer to them as existing laws. So the next in line is common law. And then again, Article 11 to explain what a common law is. So when we say common, we are talking about common law of Ghana. Please know, not the common law that you may learn in, is it equity and succession? Yes, you may learn in equity and succession. Here we are talking about the common law of Ghana, and the common law of Ghana comprises of the rules of general application known as the common law, the doctrines of equity, and the rules of customary law. So here, when we say common law, we just mean all the laws that we inherited from our colonial masters. So all the laws that were passed by the Parliament of UK for our purpose when they were our colonial masters, or when they were ruling us. All those are common law. And then aside that, we are also looking at doctrines of equity. So when we say doctrines of equity, we are talking about all the principles that were passed at a time when the common law was so rigid that it could not provide the needs of everybody, because there were times where the common law did not provide that flexibility. So at the time, the Lord's Chancellor, you know that back in the days, the popes and the Lord Chancellors were very powerful. So they could decipher on a matter and say that, well, this particular issue is not provided by the law, and we believe that this is what should be done. So mostly doctrines of equity was to ensure fairness, was to ensure equity, equality, because there were situations where the law was very rigid, that the law was very strict on how certain things were done, but it just was not fair. So in those instances, we bring in the doctrine of equity, which is the doctrine of fairness, to solve such particular issues. Then we have the rules of customary law, and here we are talking about the rules of customary law that are applicable in the various communities in Ghana, and understand that the rules of customary law, we are talking about those that are determined by the Supreme Court. Because there has been in certain situations where the customary law of the land had to be determined by the highest court of the land, because you had various parties determined or trying to, state that this was what was their customary law. So the Supreme Court, had to listen to both parties, hear evidences, traditional evidence from the people, listen to what had been done over the century, and then come up to say, no, we think this is what the customary law of the land should be. So yes, so here we are talking about the customary law as applicable to particular communities. So we don't have one customary law as a Ghana. Looking at the many tribal lines that we have, or the many communities that we have, we can even have their accounts, but their customary law may be different, because every village may have how they do their stuff. So the customary law is really applicable to the various communities. So I've already talked about existing laws. So existing laws, we are talking about all written and unwritten laws of Ghana that existed before the coming into force of the 1992 Constitution. I have already talking about that. So yes, I've already talked about this. Yes. So here on the orders, rules, and regulations which are made by entities under the 1992 Constitution, we are saying that before these orders, rules, and regulations are passed, they must be laid before Parliament. They must be published in a gazette on the day it is laid before Parliament, and then shall come into force after the expiry of 21 sitting days. Unless Parliament before the expiry announce that order, rules, or regulations by vote not less than 2/3, that is 75% of the members. So for rules, orders, and regulations, for them to become law, they must be laid before Parliament. They must be published in the Gazette on the day it is laid before Parliament, and then it would come into force after 21 days. So if after 21 days, Parliament does not have any objection on that particular rule, orders, or regulations, they become law that would be used by that particular agency given the authority to make such laws under the 1992 Constitution. So we've already talked about it. So the Constitution is the supreme law of the land. Thus, any act and omission which contravenes the provision of the Constitution is void. So the highest law of the land is the Constitution. So if there's any law that is conflicting it, it is null, and then it is void. And under Article 2, the Supreme Court is vested with that authority to interpret and enforce the provisions of the 1992 Constitution. So if any arm of government is involved in activities that conflict the 1992 Constitution, or there's an act passed by Parliament or these bodies authorized under the Constitution, which that particular order, rule, or regulation conflicts the provisions of the Constitution, the law allows the Constitution to declare such provisions as null and void. And you can see that here, a very popular case is the MPP versus Attorney General. That is the 31st December case where the Supreme Court had to determine that the celebration of the 31st December, which was the day where a coup was done, cannot be a public holiday as it conflicts with the Constitution. Because under the Constitution, you cannot subvert or suspend the Constitution. So if an entity subverted or suspended the Constitution, that act cannot be celebrated as a public holiday. So in order of hierarchy, we have the Constitution, then we come to the enactments. So the enactments, I've already explained this, is that they are the laws that are passed by Parliament. I think I've already. Then we have subsidiary legislation. So let me explain. So these are legislations that are not made by Parliament directly, but by some other authority, pursuant to an authority granted by the Constitution. I've already talked about it. So, and these are the orders, rules, and regulations. So these ones are not made by Parliament. I think I've already talked about it. Electoral Commission. So Electoral Commission under law, has the power to make certain regulations, orders, or rules. So when you see subsidiary legislations, we are talking about the orders, rules, and then regulations. Don't be confused when you see subsidiary legislations. Good. So I also talked about executive instruments which is that the Constitution allows the executive arm of government, to make executive instruments, and sometimes that is what they use in imposing curfews, compulsory acquisitions of land, and then and whatnot. I think I've already explained this. So for subsidiary legislations, I think, yes, we have already talked about it, that must be laid before Parliament and then published in the Gazette, and then remain for 21 days, and then becomes law if Parliament does not have an issue with it. So then existing laws, I've already talked about it. They are laws that were enforced before the 1992 Constitution. I've also talk about the common law of Ghana. So the common law of Ghana is in threefold. We have the common law, we have the doctrines of equity, and the customary rules of Ghana. I've already explained all this. Then we have judicial precedents. So judicial precedent also forms part of common law. This is because we are talking about decisions that have been passed, in the higher courts of the land that, try to determine certain questions of law and then certain questions of fact. And these are binding. So if today the High Court or the Supreme Court passes a law or makes a judgment saying that the government is right to impose a curfew for 21 days, it means that in the next 21 days, depending on the particular circumstances, the government can impose a curfew. So then that becomes a law. So sometimes by interpreting and enforcing, you will see that they may also be making laws on their own, which forms part of our laws, which we call them judicial precedents. So the last one on the list is writings of jurists and then publicists. So you have writers and then certain publicists, sharing their opinion or their ideas on certain matters. Sometimes when it becomes very difficult to decipher what the position is, sometimes you see the judges relying on the ideas of some of the bright writers and publicists around. And my very favorite is Prof. Atuguba. Yes. Yes. So thank you very much. I think I've been very, very snappy about this. I think it's quite straightforward. I didn't want to make it very boring. So let me try to provide some summary on what I've been saying all this while. So on this, we are looking at the sources of law. So I said when we talk about the sources of law, we are trying to see where these laws come from. We are trying to understand the source. We are trying to understand the origin of the laws. We are trying to understand where these laws derive their authority from. We are trying to understand where these laws derive their validity from. These terms are very, very, very important. So depending on where they derive their source, their origin, their validity or their authority from, we can determine which law is higher than the other, because when there's a conflict between two laws, we must always determine which one is superior to the other and which one must be obeyed. And we mentioned that Article 11 of the 1992 Constitution provides a very clear picture on the sources of laws in Ghana. So you have the Constitution, you have enactments, you have rules, regulations, and others, which are also called subsidiary legislations. You have existing laws, you have the common law of Ghana, which is in threefold. That is the common law, the doctrines of equity, and then customary law as is applicable in the various communities. Then you also have judicial precedents, and then you also have writings of publicists and then jurists. So we see it's a very, 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 very simple, straightforward topic. I hope the understanding is very clear. If it's not and you have any question, as always, feel very free. Get in touch, send me a message. I would respond. Once again, thank you very much for spending time with us. If it is your first time, kindly like, kindly subscribe, kindly share, and then get in touch. Thank you and have a blessed day. Bye-bye.